And now give the floor to the representative of Sri Lanka.
Mr. President, Excellencies, distinguished representatives, I am pleased to be here today on behalf of my country, addressing this important occasion commemorating the 40th anniversary of the adoption of the Convention on the Law of the Sea. The Law of the Sea Convention, as a comprehensive framework governing users of the ocean, sets forth an ambitious agenda for the world in using and protecting the ocean for the common benefit of mankind. With its commitment and contribution, Sri Lanka wishes to reiterate that the culmination of many years of work within the Convention has demonstrated the importance, I say, of multilateral efforts in establishing international norms. In this backdrop, the Convention turned a new chapter, so to speak, in the development of the law of the sea, as it established a legal framework for the conservation, management, exploration, and exploitation of the living and non-living marine resources within and beyond areas of national jurisdiction. The codified principles have given much impetus to the deep seabed beyond areas of national jurisdiction as a common heritage, I say, of mankind, to be utilized for the benefit of the international community. Mr. President, as we celebrate the 40th anniversary of the United Nations Convention on the Law of the Sea, concluded in Montego Bay, Jamaica on the 10th of December 1982, we need to take stock, I say, of the valuable contributions of this agreement, which can be seen, if I was to describe it, as a monumental achievement of the international community, second only, I say, to the Charter of the United Nations. UNCLOS, as we know, introduced many new features to the law of the sea, going beyond gathering the main principles of customary law. There are among the main innovations archipelagic waters, the International Tribunal of the Law of the Sea, the qualification of the seabed beyond national jurisdiction as a common heritage of mankind, and above all, the exclusive economic zone. In this process, it enshrined customary maritime law, but it also contradicted it by extending national claims far beyond to the sea, well beyond traditional claims, in the form of a sui generis exclusive economic zones. By fiat, this creation of exclusive economic zones established new claims and conflicts that never existed before. Distinguished delegates, the exclusive economic zones particularly reflects the complex balance of the Convention, which required many years of negotiations. It has made possible, I say, to please both the coastal states, especially developing states, about their rights concerning the resources of their waters, and the major maritime powers attached to the resources, to the freedom of navigation and trade. Furthermore, UNCLOS has helped to settle many maritime disputes by clearly defining the different maritime spaces and their extent. It has helped to resolve disputes and to strengthen legal stability. The concept of the territorial sea is a particular telling example, distinguished delegates. Although it was conceived in the early days of the law of the sea, states have never managed to agree, you will appreciate, on its breadth. UNCLOS, however, clarified this point, and now the vast majority of states claim a territorial sea of 12 miles or less, including some that are not parties to UNCLOS. The Convention has thus become a guide to the behavior of states on maritime matters. It's virtually the gospel of the seas. Mr. President, the UNCLOS, again, is an innovative convention, a modern text that has not suffered from the past 40 years. On the contrary, some provisions are even more relevant today. This is the case, for example, of the provisions concerning the exploration and exploitation of the seabed, for which the technological progress since the 1980s has made it possible. In addition, the Convention bears a witness, I say, to the importance of environmental concerns for the negotiators at a time when these subjects were less of a priority. As a result, the Convention includes a comprehensive section on the protection and preservation of the marine environment. Distinguished delegates, yet we must continue to strive with greater vigor and political competency to maintain the momentum, lest we lose the unique opportunity to reap its benefits. Like many other provisions, the UNCLOS, the concept of the EEC, has been incorporated into international customary law, making it legally binding on all states. Mr. President, non-ratification of UNCLOS may also negatively impact other interests, I must warn, in many global regions. Taking note of non-ratification by developed states, other states may disregard key aspects of international law, such as the freedom of navigation or the rights under the EEZ. These continued impediments posed to ratification of the Convention by industrialized states require serious negotiations, I say, to overcome obstacles and must be made to bear fruit. At the same time, countries must keep in mind how maritime trade culminated from the oceans since ancient times, symbolizing prosperity and power to the nations. At this juncture, Mr. President, when we celebrate the 40th anniversary, it is paramount that we join hands to keep the spirit and work together and overcome obstacles through mutual cooperation. Mr. President, in this context, many initiatives are in place to achieve justifiable better distribution of wealth to benefit all through a substantial compromise and a redimensioning, if I was to use that expression, of recommendations that emerge through various multilateral discussions. We must continue to lead that objective and instill global efforts of mankind to work collaboratively and inclusively in the development of the Convention in the years ahead. The discussions in this arena have concluded that the Convention itself is a monument to the possibilities of global multilateral diplomacy. The Convention can be a pillar, I say, to emerge consensus on reconciling important security, economic, environmental, and other interests, giving precise norms and rules that can narrow the issues, resolve disputes to achieve results for common interests in the discourses regarding policy making. And finally, let me conclude by reiterating the position that the Convention has served the goals of the ocean use by mankind over the last 40 years, and its prominent role will continue to grow, and the important work within it will no doubt form a legal framework within which all countries in the ocean and the seas may be carried out, contributing to fundamental importance for the maintenance and strengthening of international peace and security and sustainable development goals. Mr. President, I must, of course, with pride recall the substantial contribution to the development of UNCLOS by my predecessors. The giants in this field, the late Shirley Amarasinghe, Susantha D. Alvis, the Ambassador Karen Breckenridge, Rodney Vandergert, and others in the specialist personalities of Chris Pinto and Dr. Hiran Jayawardena, who had worked tirelessly to develop the law and the connected concepts to meet contemporary challenges. I take this opportunity to commend the tireless efforts, of course, of the Division for Ocean Affairs and the Law of the Sea for their valuable efforts in making arrangements for guiding the process, taking forward the framework for ocean governance well into the future. I thank you, Mr. President.
Je remercie le représentant du Sri Lanka.
I thank the representative of Sri Lanka.